The Honorable Vice President.
Let us pray. Almighty God, we willingly acknowledge you as the Supreme Being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Oath or affirmation announcements by the Vice President.
Honorable Senators, I wish to advise that the President of the Senate, Senator the Honorable Christine Kangaloo, is currently out of the country. Honorable Senators, I have received the following correspondence from Her Excellency the President Paula May Weeks, ORTT. The Constitution of the Republic of Trinidad and Tobago, by Her Excellency Paula May Weeks, ORTT, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces, to Mr. Augustus Thomas. Whereas Senator the Honorable Christine Kangaloo is incapable of performing her duties as the President of the Senate by reason of her absence from Trinidad and Tobago, and the Vice President of the Senate is required to perform the duties of the President of the Senate, as a result, a vacancy has arisen in the Senate. Now, therefore, I, Paula May Weeks, President as aforesaid, acting in accordance with the advice of the Prime Minister, in exercise of the power vested in me by Section 44 of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Augustus Thomas, to be temporarily a member of the Senate with effect from the 9th of April 2019 and continuing during the absence from Trinidad and Tobago of Senator the Honorable Christine Kangaloo, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, this 8th day of April 2019. Honorable Senators, the Senator is required to take the oath.
I, Augustus Thomas, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibility to the people of Trinidad and Tobago upon which I am about to enter.
Bills brought from the House of Representatives, petitions, papers.
Minister in the Ministry of Finance.
Thank you very much, Mr. Vice President. Mr. Vice President, I have the honor to lay on the table the following papers as listed on the order paper and supplemental order paper in the name of the Minister of Finance. The Financial Amendment Revocation Regulations 2019. The annual report of the First Citizens Asset Management Limited, renamed the First Citizens Depository Services Limited, effective December 12, 2018, for the year ended September 30, 2018.
Leader of Government Business.
Mr. Vice President, I have the honor to lay on the table the following papers as listed on the order paper and supplemental order paper in the name of the Vice President and the Minister of Sport and Youth Affairs. The 31st Annual Report to the Parliament of the Integrity Commission of Trinidad and Tobago for the year 2018. The Ministerial Response of the Ministry of Sport and Youth Affairs to the 16th Report of the Public Administration and Appropriations Committee, 3rd Session, 2017-2018, 11th Parliament, on the examination into the implementation of the Public Sector Investment Program.
Reports from committees.
Senator the Honorable Robert Lehunt.
Mr. Vice President, I have the honor to present the following reports in the name of Minister in the Ministry of Finance, Alison West, as listed on the supplemental order paper in her name. The interim report on the Joint Select Committee, 4th Session 2018-2019, 11th Parliament, established to consider and report on the Trinidad and Tobago Revenue Authority Bill 2018.
Urgent questions.
Senator Mark.
Thank you. Thank you, Mr. Vice President. To the Honorable Minister of Public Utilities, in light of the partial shutdown of the Carney water treatment plant and its effect on the water supply of numerous communities during the harsh, dry season, can the Minister indicate what urgent measures are being undertaken to mitigate same?
Minister of Public Utilities.
Mr. Vice President, let me state that the shutdown of the plant yesterday by WASA was as a result of work being conducted and the correct interchange that needed to be done on that particular urgent project. That being said, the water treatment plant from Carney was partially shut down due to the repairs, and as such, the plant, which was producing approximately 60 to 65 million gallons of water a day, was reduced to 15 million gallons, with the major places being impacted being the north of Trinidad, because 15 million gallons were basically sent to the south of Trinidad. The necessary notices that were sent out with regard to those particular areas affected in the north Trinidad. And again, I apologize, but it was something that could not have happened, could not have been prevented. As usual, during these times, the Water and Sewerage Authority, they do have an emergency plan when they are shutting down, with priorities being given to ensure that the sick, the elderly, the hospitals, government offices, etc., that they are provided with required water to ensure that they are able to operate as usual. And those things were put in place. Additionally, a lot of truck-borne water supply was provided to the required people as requested. I am pleased to advise that at 6:05 p.m. on April the 8th, 2019, that water, the southwest Trinidad was the particular area, the water treatment plant was restored with water yesterday at 6:05 p.m. And in the north at 7:50 a.m. on April the 9th, the plant was back up to capacity, producing 50 million gallons. So those areas and the effect, as I said, was short-lived. However, as a result of the schedules that we have in place, we will find that it will take probably a couple of days as someone missed their schedules before you to get back into the rhythm. We are and we continue to be in a harsh dry season period, and 50 million gallons is it's about 20% less than we would have normally been able to produce at that plant.
Mark, supplemental.
Thank you. Mr. Vice President, through you, can the minister indicate what were the specific works at the Deoroop interchange that would have resulted in this particular situation affecting the Carney treatment plant?
Minister of Public Utilities.
There were the works, as I said, was at the Deoroop interchange, and it was considered, it centered around the changing of a particular valve at the interchange to facilitate future works going on there. At that point in time, because that needed to be done, there was also some maintenance work at the Carney water treatment plant that was also undertaken due to the fact that that critical work needed to be done at the Deoroop interchange.
Senator Mark, second supplemental.
Yeah, Mr. Vice President, can the minister indicate how many days will it take for citizens to secure their normal, regular supply of water, having regard to the period it takes for the system to kick in and for water to flow? Can you share with us how long it will take citizens to have their regular supply restored?
Minister of Public Utilities.
Thank you very much, Mr. Vice President. As I mentioned, as WASA had put out in their press release, because the country is presently on a schedule basis, and if you miss your time and the critical nature of that plan, they had put that it could take as much as up to 3 days. However, the time that the system was expected to be restored, as I said, it happened yesterday and today. The work was completed a lot earlier, and we expect that within a maximum of 3 days, but we will expect, because the work was done earlier, that time has been shortened, and we will expect people to get back to their regular schedule, within the next couple of days.
Questions on notice, questions for oral answer.
Leader of Government Business.
Thank you very much, Mr. Vice President. Mr. Vice President, the government is pleased to announce it will answer all questions, save and except question number 132, 172, and 176, of which we ask for deferral of 2 weeks.
Honourable members, the deferral that the member seeks is so granted. Senator Mark.
Thank you. Question number 96 to the Honorable Minister of Education.
Minister of Education.
Thank you very much, Mr. Vice President. Mr. Vice President, the Ministry of Education is committed to ensuring that all students have access to quality education. I am pleased to report that the issue of pigeon infestation at the Ragananan Road Government Primary School has been fully resolved through work done by the National Maintenance, Training and Security Company at the school, and the problem no longer exists. Thank you very much.
Senator Mark, supplemental.
Mr. Vice President, can the Honorable Minister share with us when this situation of addressing the infestation occurred or took place? When?
Minister of Education.
Mr. Vice President, the information that has been made available to me is during the Christmas vacation and during the first few weeks of this term that matters attended to. Thank you.
Senator Mark, any more supplemental? Senator Amin, supplemental.
Mr. Vice President, to the Minister, can you indicate what took so long to have this situation addressed that we had to come here to ask questions? What were the delays in treating with the issue there?
Minister of Education.
Mr. Vice President, I do not share the view that this matter took long in having it resolved. As all of us would know, where there's an issue of pigeon infestation or infestation by any rodent, there's a process that must be followed. And we followed that process from the time we got the report until the time of its completion. Thank you.
Senator Mark.
Can I ask the Honourable Minister what measures has been taken by MTS, well, by the Ministry of Education through MTS to avert a repetition of this situation in the not-too-distant future?
Minister of Education.
Mr. Vice President, I'm not too clear on the question that has been asked. I'm not sure what answer Senator Mark would like when he asked what measures MTS has taken. There are a number of schools that have been affected by some form of infestation, and the MTS would get usually the expert. There's an expert firm or an expert contractor to do the job. And in terms of the details, I'm not in a position to give any information with respect to those details. Those details are left to the technical persons, not the Minister of Education.
Senator Mark.
Can I ask?
Last supplemental.
Yeah, Mr. Vice President, can I ask the Honourable Minister whether the Education Facilities Company Limited, that normally would have dealt with these matters, have that particular company been liquidated and overtaken in due course by the MTS? Can you ask, in other words, Mr. Vice President, I'm asking if MTS has replaced the Education Facilities Company to deal with matters of school maintenance. I'm just trying to get clarification from the Honourable Minister.
I won't allow that question, Senator Mark. Next question on the order paper.
Question number 97 to the Minister of Works and Transport.
Minister of Works and Transport.
Vice President. Mr. Vice President, the PTSC has conducted its investigation, which have been concluded into the larceny of its bus on November 19, 2018 from the Chaguanas depot. The investigation has revealed that a third party is responsible for the breach resulting in the larceny. The PTSC is not liable for any third party claim arising out of the breach and is working with its legal team and insurance brokers to resolve this serious matter. The PTSC is committed to finding an amicable resolve. The PTSC continues to be in touch with all the relevant parties. I thank you.
Senator Mark,
Through you, Mr. Vice President, could the Honourable Minister indicate whether this report that has been concluded, and since they are not taking responsibility, has that report been referred to the police?
Minister of Works and Transport.
Mr. Vice President, if a bus is stolen, and if Senator Mark continue to read the newspaper, you'd realize that this matter was a police matter. It's the police who went on the scene and apprehended the person who stole the bus. This matter have been attracting the attention of the police from the day the incident happened. So it is a police matter, and we consider it to be a very serious matter where the parties that are culpable will be held accountable at the end of the day. Thank you.
Mark, second supplemental.
As a company that is committed to social corporate responsibility, can you tell the Senate what meaningful steps or measures are being taken by the PTSC to bring some relief to the suffering families who have been victims of this particular incident? Can you share with us?
I won't allow that question, Senator Mark. Next question, next supplemental, if you have it.
Can I ask through you, Mr. Vice President, if you'll allow this one, can I ask whether the minister is prepared to table that report in the parliament for our viewing?
Minister of Works and Transport.
Mr. Vice President, I cannot bring to the Parliament a police report or a police investigation. I am sure if the senator wants that, he knows that he needs to probably write to the Ministry of National Security for that kind of information. Thank you.
Senator Mark, last
Confused
supplemental.
these days because of all kinds of situations. But I didn't ask for a police report. I asked for the report that was conducted and concluded, as you indicated, the Honorable Minister, that is so, concluded by the PTSC into this particular matter. I didn't ask for no police report. I asked for the PTSC report, sir. Could you tell us?
Minister of Works and Transport.
Again, Mr. Vice President, Senator Mark should be aware of the laws of this country, and there are lawyers and attorneys on his bench who should be able to advise him. If there's an investigation, there's a police matter, and people are to be charged, I cannot bring evidence to the Parliament until that has been resolved.
Next question, Senator Mark on the order paper.
Yeah, thank you. Thank you, sir. Question number 98 to the Minister of Works and Transport.
Minister of Works and Transport.
Thank you, Mr. Vice President. Mr. Vice President, the disciplinary process followed by the Airport Authority of Trinidad and Tobago was consistent with Article 25 of the Memorandum of Agreement between the Airport Authority and the Estate Police Association and the principles of natural justice. Article 25 states that disciplinary action against a precepted estate police officer shall be in accordance with the Supplemental Police Act, Chapter 1502, and any amendment thereafter. Disciplinary action against an unprecepted officer shall be in accordance with the Airport Authority of Trinidad and Tobago security rules and regulation. As soon as possible, a copy of the authority rules and regulation shall be given to each officer within 1 year of this agreement. Mr. Vice President, it is noteworthy that the affected officer was afforded the opportunity to be heard in accordance with the principles of natural justice prior to any decision being made by the authority. The officer has since reported the matter to the Ministry of Labor as a trade dispute. As such, in the interest of protecting the affected officer's interests and those of the authority in those proceedings, I wish to reserve the provisions for more specific procedural details of this proceedings. I thank you.
Senator Mark, supplemental.
Mr. Vice President, can the Honorable Minister indicate whether the officer in question is still on suspension?
Minister of Works and Transport.
Mr. Vice President, I will have to get that information and at a further time submit it to the Parliament. Thank you.
Senator Mark, second
So
supplemental.
you don't know if the officer is suspended, still on suspension?
Senator Mark, are you re-asking the first question that you just asked? Okay. Second supplemental.
Yeah. Mr. Vice President, can the Honorable Minister indicate whether this entire disciplinary process was not a charade to cover up?
Senator Mark, I'm not going to allow that question. I could stop you right there. Do you have a third supplemental question?
Can I ask the minister whether he's aware that the officer in question did not commit any wrong?
I'm not going to allow that question, Senator Mark. Do you have a fourth supplemental question?
Can we ask him, through you, when will the officer be reinstated in his job?
Minister of Works and Transport.
Mr. Vice President, I did indicate a while ago that I will get the information if the officer is on duty. I would just presume that flowing from that, the question the Senator is asking, when will he be reinstated? I just indicated that I was not sure if he was if he was reinstated. Mr. Vice President, I also did indicate that this matter is before the Ministry of Labor as a trade dispute, and it will really be unethical of me to comment on what is happening with the matter. Thank you.
Senator Mark. Let's not get into that tit for tat and continue to follow the procedure as it relates to answering oral questions. Senator Obika, next question.
Thank you, Mr. Vice President. Question number 134 to the Minister of Finance.
Minister of Public Utilities.
Mr. Vice President, for fiscal year 2018, the end of month government net overdraft position as a percentage of available advances was as follows. October 2017, 73.2%. November 2017, 88.8%. December 2017, 62.6%. January 2018, 55.3%. February 2018, 72.1%. March 2018, 79.6%. April 2018, 75.4%. May 2018, 90.3%. June 2018, 90.8%. July 2018, 87.3%. August 2018, 70.9%. And September 2018, 81.5%.
Senator Obika, any supplementals?
Thanks, Mr. Vice President. This response does not answer the question in the way it is meant to be answered, meaning what was the size of the overdraft, dollar value?
No question, supplemental?
Yes, Mr. Vice President.
No. Did you ask the question? You made a statement.
The question states what is the size of the overdraft for the month. So basically, what is the dollar value of the overdraft, not a percentage of advances. What is the dollar value of the overdraft for each month of fiscal 2018?
Minister of Public Utilities.
Mr. Vice President, to my colleague, I've taught him a lot in life, having worked with him closely at a different part. But one of the things I didn't pass on to him was his ability, because I didn't know we would have been in this place, of how to ask specific questions if you would like to get specific answers. So we have provided the information. You have asked for the size, and we have given to you the size of the overdraft in a manner that we felt that was appropriate. If you would like to get any more specific questions as per that information, again, if he asks the appropriate question for the balances, we will be more than willing to provide that at a subsequent time. But I'm not in a position to do that at this point in time. But I will pass that teaching over to you at some other time, sir. Thank you.
Senator Obika, any more supplementals?
I just want to put to my former mentor that
Senator Obika, you may take your seat. We are currently engaged in oral questions as it relates to the procedure of the Senate of the Republic of Trinidad and Tobago. We are not engaged in a debate. You're either asking a supplemental question based on the answer given, and it is either allowed by the chair or it's not allowed. Do you have a supplemental? You may ask your supplemental question.
Thank you very much, Mr. Vice President. So can the Honourable Minister give an undertaking as to when we can get the response, given the nature of our request? We would like to get the dollar value of the balances of the overdraft for the months of fiscal 2018.
So you're asking when, specifically? Yes. Minister of Public Utilities.
Mr. Vice President, as I said, that's a question. If it's asked in an appropriate manner, we are compelled at this side of the House to answer questions once they are provided to us, so that it goes through the proper channel. So if it is written and asked in an appropriate manner and put forward as a question, I'll be more than willing, I'm sure, if it passes all tests, to provide the information. And because we will need that, as you would recognize, that particular information will require me to be able to say at a different time. So please pose the question in the appropriate form.
All right, let me just intervene here briefly. So a question is asked and an answer is given. And you can ask a supplemental question based on the answer that is given. The question was just asked to specify further in relation to the first question that was asked and the answer that was given. The Honorable Minister has given a response specific to that answer. Senator Obika or any other member in the Senate, do you all have another supplemental question in relation to the original question and answers given? Senator Mark.
Can I ask the Honorable Minister of Public Utilities to provide, whether he can provide, Mr. Vice President, the Senate with the specific balances on the government's
So that
overdraft?
question was asked by Senator Obika. It was answered by the Minister of Public Utilities. So I'm not going to allow that question because it was asked and it was answered. So it's becoming repetitive now. That is the third question asked on this particular oral question. There's one more. Does any member have a fourth supplemental question? Senator Obika.
Thank you very much, Mr. Vice President. Can the Honourable Minister indicate which of the months, if any, the government would have exceeded the required level of the overdraft, given the law?
Minister of Public Utilities.
Mr. Vice President, based on, again, the percentages and the information provided, I could see there was no month that I would suspect if you were in excess, you would be over 100%. And in all months, we were below 100% threshold. So I would say, based on that and based on the information before me, there was no month based on the information that was provided.
Speaker, next question on the order paper.
Thank you very much, Mr. Vice President. Question number 140 to the Minister of Social Development and Family Services.
Minister of Social Development and Family Services.
Thank you very much, Mr. Vice President. For the period October 1st, 2018 to January 31st, 2019, 1,137 recipients were added to the food support program. Thank you, Mr. Vice President.
Senator Obika, any supplementals?
Can the Honourable Minister indicate what is the total number given this addition to the food support program?
You might want to rephrase that question. She gave a number in response to the question asked.
The Minister indicated 1,137 persons were added. Can the Honourable Minister indicate what this has carried the total number of persons on the food support program to?
Oh.
Yeah.
Minister of Social Development and Family Services.
Mr. Vice President, I would like to give that information at a later date because it would be specific as at January 2019, and I do not have that figure at this point in time.
Senator Obika, any more supplementals? No. Next question on the order paper, Senator Obika, if you have no more supplementals. You have no more supplementals? You have a supplemental?
I have a supplemental.
Senator Amin, supplemental.
Thank you, Madam. Mr. Vice President, to the Minister, can you indicate what are the initiatives of the ministry given the situation with more people losing their jobs, specifically targeting those government agencies that are retrenching, such as Petrotrin and others?
I want to allow that question, Senator Amin. Next supplemental, if anyone has it, Senator Hussain.
Thank you very much, Mr. Vice President. Can the Honourable Minister indicate, Mr. Vice President, what is the value of these food cards that are being distributed to these individuals?
More specific.
The value in terms of what is the dollar value, because these food cards are given at a dollar value per month. What is the dollar value of these food cards that have been distributed by the ministry?
Minister of Social Development and Family Services.
Mr. Vice President, there are three denominations of the food card. We have 510, 650, and 800. That's the amounts that the food cards now value.
Is there a fourth supplemental to this question? Senator Mark.
Can I ask my honourable colleague if it is possible, Mr. Vice President, for the Honourable Minister to provide the Senate with a breakdown of well, first of all, the number of persons benefiting from the 500 range, 600 range, 800 range, in terms of the 1,000 food cards that have been added. Can you provide us with that information?
Minister of Social Development and Family Services.
Mr. Vice President, given the question that was originally posed, I am not in a position at this point in time to give a breakdown of the number of persons receiving the different food cards, the different categories of food card. If necessary, it can be provided at a subsequent time.
Next question on the order paper, Senator Obika.
Thank you, Mr. Vice President. Question number 163 to the Minister of Health.
Minister
of Health.
Thank you very much, Mr. Vice President. The Ministry of Health has taken note of the warning issued by the Executive Director of the Caribbean Public Health Agency, CARPHA, regarding the possibility of a dengue outbreak. To this end, over the past 2 years, the Ministry of Health has been using a geographic information system to plot all arbovirus disease cases, and together with information provided from various workstations across the country, special attention is being placed on high-risk areas, including tire shops, scrap yards, and areas with recorded high disease burden historically. The implementation of this arbovirus integrated management strategy for vector control has resulted in tremendous benefit to the Ministry of Health and, by extension, the people of Trinidad and Tobago. This is evidenced by a noteworthy reduction of both suspected and laboratory-confirmed dengue cases during the period 2014 to 2018. For suspected dengue cases, it decreased significantly by 87.5% from 5,150 cases in 2014 to 644 cases in 2018. And for laboratory-confirmed dengue cases, it decreased significantly from 331 in 2014 to 3 cases in 2018, and this represents a reduction of 99%. Further, in 2016, the Ministry of Health amended the public health yellow fever regulations, where the fine for any offense committed increased from $500 to $3,500. Subsequently, there were 3 initial complaints, which were remedied thereafter, and hence these matters were withdrawn. In keeping with the warning issued by CARPHA about a possible dengue outbreak, the Insect Vector Control Division has embarked on the following initiatives. 1, execution of a vociferous campaign to reduce mosquito breeding and spread of diseases through the ongoing perifocal work, larviciding, adulticiding, source reduction, and health education community participation. These activities are done routinely throughout the year and with approximately 3 to 4 cycles of perifocal work being completed annually. This means that each home is visited approximately 3 to 4 times per year in high-risk areas. The implementation of a planned school spraying program to ensure that preschools, primary schools, and secondary schools are sprayed during the Easter vacation periods and other vacations. Perifocal work routinely at ports of entry, given the increase in visitors. The provision of an adequate supply of resources, including chemicals, including 400 liters of alpha cypermethrin, 5 new ultra-low volume machines, ULV, 10 public address systems, and more than 10,000 insecticide-treated nets, which are being distributed at risk areas, as well as the procurement of personal protective equipment. Despite the Ministry of Health's best efforts, which have undoubtedly borne results, it must be noted that citizens have a significant role to play in reducing mosquito breeding and restricting the spread of vector-borne diseases. Citizens are urged to ensure that these potential breeding sites, including flower pot saucers, vases, tires, buckets, barrels, plastic drums, and other water storage containers are regularly cleaned, removed, turned over, or treated to support the ministry's source reduction efforts. Thank you very much, Mr. Vice President.
Senator Obika, supplemental.
Thanks, Mr. Vice President. The follow-up I'd like to ask the Minister, thanks for the comprehensive response, is given this warning by CAPA, can the Minister give any indication as to the distinction between malaria and dengue symptoms, given this warning and his response, just for the public's benefit?
I'm not inclined to allow that question, Senator Obika. Next supplemental, if you have it. Senator Amin.
Mr. Vice Chairman, to the Minister, can the Minister indicate what measures are being taken to ensure that the agencies have the resources, because we have had instances where they did not have the chemicals and the manpower and so on. Has any steps been taken to ensure that they have the requisite resources?
Minister of Health.
Senator Amin, I completely refute your argument that there were no chemicals. The country has never been short of chemicals, and that is shown in the figures I gave you. Why spread those rumors? And I clearly said 400 liters of alpha side. Senator Amin, that is clearly untrue. Why would you do that?
I will share some information with you.
But, Mr. Vice President, what is noteworthy is that the government alone can't do this, because there is something called resistance to the chemicals being used, and that is why we are focusing on source reduction at the level of the householder. Mr. Vice President, I visited a house recently where a person was blaming the government for mosquitoes. I walked into her yard. There were 21 flower pots with 21 saucers, with 21 breeding sites, because each saucer had water. It is not inconceivable that in those 21 saucers, 10 females could lay eggs. Each female could lay 150 eggs. That is 31,500 eggs in one yard. And with a 1-to-1 ratio of male to females, and the females are the ones that bite and spread disease, you have 16,000 female mosquitoes being bred in a house. And that is the problem we are facing. So the citizens have to get behind with source reduction, because you can't spray more than every 4 months, because the mosquitoes will build up resistance. And resistance to insecticides is a global issue facing all public health. So it's a combination between the government and the citizen, and I cannot beg citizens enough. Empty your vases, don't have breeding sites in your homes with flower pots, all of these things, your barrels, your gutterings. Please clean them. That is your responsibility, not the state's. Thank you very much, Mr. Vice President.
Mr. Vice President, thank you very much for the opportunity. Mr. Vice President, through you to the Honorable Minister of Health. Could the Honorable Minister of Health tell us when was the last time that the insect vector control unit visited the area of Farm Road in the constituency of St. Joseph, which has much more than 21 saucers, and there are many tires and many areas for breeding, and it is a very high-risk area for the infestation of mosquitoes and the spread of dengue.
I won't allow that question. Senator Ramdeen. Senator Richards.
Thank you, Mr. Vice President. Can the Minister indicate, given the last response, what the data is presenting in terms of the insecticide effectiveness, particularly in the known breeding grounds with high incidences?
Minister of Health.
Thank you very much for that most sensible and noteworthy question. Mr. Deputy Speaker, the issue of mosquito resistance to insecticides is a global one. In talking to the experts in this field, I am told, and I know this for a fact, that no new insecticides, no new adulticides have been developed by the companies for the past 20 to 30 years. So that is why in Farm Road or anywhere else, you don't spray more than a 4-month cycle. Whether it's Farm Road, whether it's Valsane, whether it's on the train line in Marabella, whether it's in Bel Air. The key to this is in citizens taking responsibility for their immediate environment. That is the key. So I completely reject, again, Senator Ramdeen's assertion. Don't play politics with public health. Whether it's Farm Road or Bel Air in San Fernando, the key is a partnership between government and citizens, because indiscriminate spraying more than a 4-monthly cycle leads to the mosquitoes developing resistance, and then you create a bigger problem where you throw the kitchen sink at the mosquito and they will not die because they have developed resistance. I urge my colleagues opposite not to play unnecessary politics with a very serious public health issue. Public health is beyond the realm of petty politics. Thank you, Mr. Vice President.
Next question on the order. Next question on the order paper, Senator Hussain.
Thank you very much, Mr. Vice President. Question number 177 to the Minister of Community Development, Culture and the Arts.
Minister of Community Development, Culture and the Arts.
Thank you, Mr. Vice President. The cost of renting the National Academy for the Performing Arts for the celebration of the 63rd anniversary of the People's National Movement was $23,900, inclusive of a cautionary deposit, refundable of $6,400. The rental fee was paid.
Supplemental.
Mr. Vice President, can the Minister indicate whether or not this is the actual rental price or this was a discounted price given to the PNM?
Minister of Community Development, Culture and the Arts.
The rental price charged upon application for the event was $23,900, and that was paid.
Supplemental, Senator Hussain.
Mr. Vice President, can I then ask the Minister, what is the ordinary rental price for the National Academy for the Performing Arts so that citizens can access this facility?
Minister of Community Development, Culture and the Arts.
Certainly, Mr. Vice President. Any citizen or organization wishing to rent the National Academy for Performing Arts applies, and based on the event and what is happening there, it's based on a range. And so any applications made are determined by the NAPA administration, and they are given the rental amounts. So it varies.
Is the Minister confirming that persons or organizations who wish to use NAPA, the cost for rental is a discretionary cost?
Minister?
Certainly not. There's a range, a set range, with different values depending on who is asking to rent it, and that range is applied once it is given. It depends on the nature of the event and the number of days and that kind of thing, and where exactly they want to rent. Some people want to rent the lobby area, some people want to rent the auditorium, so it depends on what is asked for. So based on what application was made, that was the rental charge applied, and it was paid in full.
Supplemental. Fourth supplemental, Senator Hussain.
Thank you very much, Mr. Vice President. Can the Minister then share with this Honorable Senate the range in which NAPA is being rented at that she mentioned?
I won't allow that question because I understand the question, but the nature of the question would require something a little bit more specific than what the Minister would be able to answer at this particular point in time. That was your fourth supplemental, and that's the end of supplementals on this particular question. If we're moving on to the next question in the order papers, Senator Hussain.
Thank you very much, Mr. Vice President. Question number 178 to the Minister of Public Administration.
Leader of Government Business.
Thank you very much, Mr. Vice President. Mr. Vice President, the Government Plaza Courtyard in Port of Spain was rented to the People's National Movement for the Party We Love Fit. Let me repeat that. The Party We Love Fit. The Party We Love Fit. In February 2019, at the normal commercial rate of $26,375, the full sum of which has been paid. We're not sponging on the government.
Senator Hussain, supplemental on this question.
Can the minister indicate whether or not this is the ordinary rental price, or is this subject to the same range in which the Napa is being rented at, Mr. Vice
Leader of
President?
Government Business.
Listen to my answer carefully, Senator, through you, Mr. Vice President. At the normal commercial rate of $26,375.
Second supplemental, Senator Hussain.
Yes, Mr. Vice President. Can the minister indicate whether or not any part of this $26,375 is refundable?
Leader of Government Business.
Negative, that was payment in full for the facilities that the party rented.
Mr. Vice President, is the minister then confirming that that if any person wants to rent the government campus plaza, there is no security deposit to be paid?
Leader of Government Business.
I'm not sure about that, but my information here is that $26,375 was charged and $26,375 was paid in full.
Hussain, fourth supplemental, or any other member. Senator Obika.
Thank you, Mr. Vice President. For the public's interest, could the Honourable Minister indicate this fee, what did it capture? Did it capture the venue? Did it cover security, parking, etc.?
I think the answer to that question is sort of encompassed when the Honourable Leader of Government Business would have given the answer. It's a rental cost. And not to sort of engage or inject myself into this, but I think the answer to your question is already inherent in the answer given. Next question on the order paper, Senator Obika.
On the draft.
All right. We're moving on to the process. We don't have much more time in relation to Senator Amin. Senator Amin. Right. So we are continuing the process of oral questions. We don't have much more to get through, and we do not have that much time in relation to the time allotted in its entirety for oral questions. So next question on the order paper, Senator Obika.
Thank you very much, Mr. Vice President. Question number 195 to the Minister of Public Utilities.
Minister of Public Utilities.
Mr. Vice President, temporary connections are mainly given to properties during their construction phase to facilitate ease of building. As such, the fees charged are based on the nature of the service to be provided, whether single phase or triple phase, and not on the type of customer, i.e. residential, commercial, or industrial. These fees charged are outside the scope of the Regulatory Industries Commission and are intended merely to cover the cost of the service and are therefore not profit-making. The fees were last reviewed 9 years ago in 2010. On the 1st of October 2018, the management of Trinidad and Tobago Electricity Commission, in an attempt to bring the existing fee structure for temporary connections more aligned with the cost of providing the service, increased these one-off charges as follows. Direct single phase was increased from $1,761.05 to $3,024.70 VAT inclusive. And direct triple phase was increased from $2,771.69 to $5,718.41 VAT inclusive.
Senator Obika, supplemental.
Yeah. Thank you very much, Mr. Vice President. Can the Honourable Minister indicate the rationale for this, which in both instances is roughly 100% jump, as opposed to a gradual increase? The rationale for such?
You're asking for the rationale, or you're asking for the reason for the gradual increase? Which is it?
No, it wasn't a gradual increase. It was a direct jump to about 100%. So can the Honourable Minister indicate as the rationale behind going for a straight increase versus a more gradual increase?
Minister of Public Utilities.
Mr. Vice President, as I mentioned, one, that these fees were not reviewed since 2010, and these fees were an attempt to bring the existing fee structure for temporary connections more in alignment with the cost of providing the service, and therefore, hence the reason that they were reviewed at this point in time, and the increase that was applied in keeping with the cost structure of providing the service.
Second supplemental, Senator Beaker.
Thank you, Mr. Vice President. Can now the Honourable Minister indicate if the fee structure is covering the cost of the service at this point in time?
Minister of Public Utilities.
Mr. Vice President, based on the information that I have before me, yes, they are more in line with covering the cost of the service.
Senator Mark, third supplemental.
Can I ask the Honourable Minister, through your good self, who determines these fees? Who determines these fees? Fees that are charged.
Minister of Public Utilities.
Mr. Vice President, I think I mentioned that also in my response, that this was a decision taken by the management and within the purview of the management to make those decisions, I suspect in consultation with the Board of Directors.
Fourth and final supplemental.
Can I ask the Minister to know which provision of the law of the Republic of TNT governing TNTech that gives the management the authority to arbitrarily increase fees? Can you point out to any legislation that gives the management of TNTech that authority? And what is your role in this whole matter as the minister?
It's Senator Mark. Okay. So I'm not going to allow that question. And that is the end of oral questions today, and that was the last supplemental question on this particular oral question. Senator Hussain, you have something or point of order to raise?
Mr. Vice President, on question number 172, which was deferred for 2 weeks on the 26th of March 2019, the 14 days has so expired. And I believe on my friend's behalf, Senator Beaker, question 134 also, Mr. Vice President.
Okay, in relation to the point of order raised, the necessary action will be taken. Senator Beaker, you want to say something?
Just a clarification, Mr. Vice President. The question that remains deferred from me is question 132, as question 134 was answered today.
Senator Hussain? That's correct? Yes. Right, so the necessary action will be taken on question 132, and is it 172, you said?
Yes, please, Mr. Vice President.
Yes, please. 172 and 132, the necessary action will be taken. Senator Mark, you had something to say?
Yeah, Mr. Vice President, can you advise me, through the relevant minister, what is the state of question 188 in the appendix of this order paper, which was due since the 30th of the 3rd? Can I ask you? Sure.
Mr. Vice President, I omitted to say when I was making my introduction to questions that question number 164 and 188, the answers have been supplied to the Parliament and will be will be supplied later in the proceedings and circulated to all members.
So, Senator Mark, you've heard the answer of the Leader of Government Business.
Motions relating to the business or sittings of the Senate and moved by a minister.
Leader of Government Business.
Mr. Vice President, having regard to the interim report of the Joint Select Committee established to consider and report on the Trinidad and Tobago Revenue Authority Bill 2018, I beg to move that the committee be granted an extension of time to May 6, 2019 to complete its work and submit a final report.
Honourable Senators, the question is that the Joint Select Committee appointed to consider and report on the Trinidad and Tobago Revenue Authority Bill 2018 be granted an extension of time to May 6, 2019 to complete its work and submit a final report. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
Public business, government business, bill second reading.
Attorney General.
Thank you, Mr. Vice President. Mr. Vice President, I beg to move that an act to provide for the registration of non-profit organizations, the establishment and maintenance of a register of non-profit organizations, the obligations of non-profit organizations, and for related matters be now read a second time. Mr. Vice President, I am very pleased to return to the Parliament and to this August chamber to carry on the business of improving Trinidad and Tobago's situation, both from a local perspective and from an international perspective. Our country, Mr. Vice President, often wrestles with analysis paralysis. We very often have the feature, the reality of proposals coming at us for an holistic improvement of an industry, of a situation, and far too often that is met with a difficulty to cause inertia. It's just too large. It's the battle we've had on the criminal justice reforms. It's the battle we had on the motor vehicle revenue authority equation, either one you want to take. It's the battle we've had on the whole of government accounting cycles. It's the battle on insurance, on credit unions, on securities, on public procurement, on campaign finance reform. Decade after decade after decade of absolutely nothing happening. Today we come to this Parliament to talk about non-profit organizations. And Mr. Vice President, non-profit organizations are often in the average soul and conscience and mind of citizens referred to as charities, NGOs, non-profit. There's an automatic consequence and consideration that these things are talking about charitable purposes. And very often that is true. Charitable, coming from the Latin root caritas, coming from age-old considerations anchored largely in our ecclesiastic experience over time in the Western world and in the Eastern world, have always found favor in the hearts and minds of Trinidad and Tobago, in its ancestors, in the people that settled us here, etc. I want to take you to something which is relevant to this debate. The law most referenced in relation to charitable purposes, from our legal perspective, the anchoring of that law is the Charitable Uses Act of 1601. That act, of course, went through various iterations. It then found a repeal and replace. Listen when? In the year 1888. Where the Mortmain and Charitable Uses Act replaced that 1601 legislation. And that particular purpose didn't find improvement until the United Kingdom in the 20th century went into a different consideration. The Charitable Uses legislation 1601, the Mortmain 1888 legislation, all anchor in a public benefit test. The public benefit test, it's a two-part test, involves the usefulness of the activity to society, and if purposes fall within three certain heads of a particular case, then there's a case to be made that you're charitable. Trinidad and Tobago anchors its charitable laws and the reliefs to be gained to charities. And let me put it this way. I'll borrow the words of Viscount Simmons in IRC versus Badley, who said, "There is no limit to the number and diversity of ways in which a man will seek to benefit his fellow man." Let's accept that as a grounding principle. But our charitable argument and our charitable purposes, the quid pro quo, the thing which encourages others to give generously of their soul to those good souls who organize and give of themselves to perform charitable purpose or to facilitate charitable purpose. In our jurisdiction, we are grounded in a case called the Income Tax Special Purposes Commissioners versus PEMCEL. And listen to the year of the case, 1891, appeal cases 531. Our Board of Inland Revenue, our corporation tax, our relief from taxation, that quid pro quo, the thing which you give to get something else, to encourage citizens to give to charitable entities, the considerations are grounded in a case which the Board of Inland Revenue relies on in the year 1891. Now, I've started with that, Mr. Vice President, because this law is a start. This law does not propose to treat with charitable purpose how you get relief, how money is to be transferred into non-profit organizations, as they're now called, or non-governmental organizations. This law does not treat with who gets more or who gets less, how much somebody should give or not give. That side of the equation, which comes in the basket of issues, is not the subject of this law. Why? This law very simply says, firstly, require people who are fitting within the definition of a non-profit organization, which can be either an incorporated or unincorporated type, require a definition to apply to whether you are a non-profit organization or not. Secondly, it says, if you are within the definition of a non-profit organization, register yourself in one location. It then says, on a bare minimum standard, apply a regulator who has functions to look at two things: the risk of terrorist financing or the risk of money laundering. Apply an appropriate regulator to have a look at this industry, if necessary, on a risk-based approach. Because I have noticed a very dangerous conversation in the public domain, that this law is a one-size-fits-all. No, sir, it is not a one-size-fits-all in the total sense of the law. The only size that fits all is to say, register yourselves. The risk analysis and the aspects of audit are not one size fits all. Clause 15 of the bill demonstrates that. If you are over $10 million in gross revenue, we ask you to subject yourselves to the potential to be audited, whilst putting upon you an obligation to keep your audited financials. We then, very specifically, find ourselves in the context of the following. Why do we want one register? We want one register because, Mr. Deputy Speaker, Mr. Deputy Vice, forgive me, I'm confusing houses. Mr. Vice President, having spent a considerable amount of time in the House yesterday, I apologize. Mr. Vice President, we say that because in Trinidad and Tobago, we have thousands of entities registered across multiple platforms. And in particular, if I go to the data, if I go to the factual matrix of Trinidad and Tobago, we have, Mr. Vice President, the following kind of information. At the Registrar General's office, total number of non-profit entities registered and charitable organizations registered, 7,698. That's at the Registrar General. We have categories of gender affairs, there's 6 of them. Child affairs, there are 25 of them. National AIDS Coordinating Committee, there's 1. PRP 6, Grants Committee 55. I'm giving you some subsets of these things. At the Office of the Prime Minister, we have 90 people registered. Ministry of Finance, we have 463 people registered. At the Ministry of Health, we have 22 registered. At the Ministry of Social Development and Family Services, 46 registered. At the Ministry of Community Development, Culture and Arts, 1,036 registered. At the Ministry of Labour and Small Enterprises Development, 11 registered. Minister of National Security, 2 registered. Of the non-profit companies incorporated by Acts of Parliament, we have 131 of them as religious entities, 124 as societies, 15 as professionals, 13 as sports, 17 as others. The British High Commission has 37 people registered. The total funds received in 1 year from the British High Commission, £2,681,264,000 sterling across 37 entities. In US dollars, that's 3.4 million US dollars. In TT dollars, 23 million TT dollars. Now, I'm raising these statistics because let's go to the government sector. In the key social programs for the social sector investment program for 2019, meaning last year's budget, Ministry of Social Development and Family Services, when we're looking to the charitable NGO aspects, hearing impaired, social enterprise management, social displacement centers, rehabilitation, reintegration, senior citizens' homes, etc. Estimate of expenditure, $27 million. Ministry of Community Development, Culture and the Arts, across a similar category of charitable or non-profit types, $59.7 million. Ministry of Rural Development, Local Government, $15 million. Ministry of Planning and Development, $7 million. Office of the Prime Minister, $15.78 million. Ministry of Health, $71 million. Ministry of Sport and Youth Affairs, $18.7 million. Ministry of Education, $58.7 million. Tobago House of Assembly, $34.7 million. Ministry of Housing and Urban Development, $235.1 million. Ministry of Agriculture, $2 million. Aggregating $544.7 million, $500 million of tax-paying money going into charitable sectors. So I'm standing here as somebody in government looking at thousands of entities with $500 million in 1 year of government money only, not including private sector money. Because obviously, private sector has a significant contribution to supporting these most excellent agencies that do yeoman service for humanity and whom I compliment on behalf of the government. But Mr. Vice President, when we're looking into this, let's get to the public procurement legislation. The public procurement legislation specifically defines what a public body is. The public procurement legislation says a public body means, and I'll jump to the point, a body corporate or unincorporated entity in relation to any function, project, scheme, or arrangement which involves the use by it of public money. In other words then, every entity in Trinidad and Tobago, whether incorporated or unincorporated, that receives $1 of public money, and I've just read out $500 million in 1 year, is a public body. And we as a country celebrated the launch of public procurement legislation. And we said in that public procurement legislation that you would be subject to scrutiny. So I'm starting with the existing laws of Trinidad and Tobago. Now tell me something, Mr. Vice President. Isn't it therefore a legitimate aim and prudent purpose being cognizant of that which you know. You know there are 8,000 plus entities registered. We know that as a matter of fact. The unregistered entities, which may number in the thousands, those entities are to be factored as well. But I have just given empirical evidence of the fact that we have a scattered registration. And let me demonstrate the proof of that. In consulting on this bill for 2.5 years and in engaging hundreds of nonprofit entities in umpteen seminars facilitated by the British, by the Americans, by the Canadians, by the various ministries, the demonstration of the difficulty of talking to the nonprofit sector was crystallized by written communication coming from someone who is well respected in our society, Mr. Colin Robinson, who I recognize as a champion advocate and who has promoted distributions. And in it, they made the point, well, we, the NGO sector, didn't know about this. And my response to that, well, we, the government, spoke to hundreds of people, but because we don't have one unified sector and we don't know the names of all people, we couldn't reach everybody. But we did reach the Law Association, we reached the ministries that deal with the NGO sectors, we reached the NGO sectors themselves. But even still, the adequacy of reach is a real issue. In the communications coming from various nonprofit organizations, listed as persons who said they did not consult are people who we receive written consultation responses from. The CSO is one of them. I have written confirmation of consultation from persons on the paperwork telling me, here are my contributions. I pour no scorn upon that because maybe their names were being lent to the argument of let's talk some more, and I'm okay with that. But what I'm saying here, Mr. Vice President, the first purpose of this legislation is to cause a unified register for all people who are qualifying as nonprofit organizations. Let's jump immediately then to what that is. You see, I've been listening to the opposition in particular in their insistence that this is not proper law, and I had sent to me a letter coming from the leader of the opposition, sent to everybody except the government, April 5th, 2019. It's, dear sir, madam, urgent consideration of non-profit organizations, bill passed in the House. And basically it says, we're not supporting the law. Typical. But that's an entitlement of the opposition to oppose. I make no condemnation of that. I welcome the submissions that will come on the floor. But let's go into who is to be registered. The definition of a non-profit organization is to be found at clause 3 of the bill. Non-profit organization means a body of persons, whether unincorporated or incorporated, same as public procurement, which A, is established primarily for the promotion of a patriotic, religious, philanthropic, charitable, educational, cultural, scientific, literary, historical, artistic, social, professional, fraternal, sporting, or athletic purpose, or some other useful purpose, and raises or disburses funds for that purpose or object. B, carries on its business without pecuniary gain to its members or officers except as reasonable compensation for services rendered, and C, restricts the use of any of its profits or other accretions to the promotion of its purpose or object. What does that translate to? That is a repetition of the definition of what a non-profit company looks like under the Companies Act. And let me strip it down even further. Simplified, this means trustees of other people's money who do not use the money for themselves for profit or for gain, and who are under a restriction qualified to be non-profit organizations, whether they are incorporated under the Companies Act or they are unincorporated. In other words then, the person who's holding a raffle to raise money for heart surgery for their relative is not a non-profit organization. The cake sale, which is raising money for somebody who is indigent or in difficulty, is not a non-profit organization. And therefore, I find it incredible to listen to the opposition's point of view on the outside of this parliament to say, well, everybody ought to be freed. The doubles man afraid. You know, this doubles man features in many debates, right? The doubles man is it's like the man on the Clapham bus in Trinidad and Tobago. The opposition's reference point, which I think is a useful one, is that the doubles man needs to be afraid. The doubles man is not a non-profit organization because the doubles man is entitled to use the profit for himself. So he's out the basket. So let's go further. Who else is a non-profit organization? What we do is, I listened to Khadija Amin this morning on the radio. The doubles man featured again on a non-profit conversation. So, Mr. Vice President, the doubles man is not a feature of yesterday. The doubles man is here today again in this debate, and we'll hear about it soon enough. So, Mr. Vice President, the second type of non-profit entity is a non-profit company. And what we do is we recognize that the company's registry has an entire section under Part 5 of the Companies Act where non-profit companies exist and are registered. And in their registration requirement, they fit the definition as this bill proposes, and they're existing in the registry. And under this law, we propose that they are deemed to be non-profit organizations. In other words, then, they do not need to go back and re-register themselves. So those are the people who are to register. Why do we say these people ought to be registered? Number one, we need one registry. To go and look in the Ministry of Sport and Social Services and other places is to put a splintered approach to recognition. Had there been one registry, I know for sure I'd be able to reach a few more entities, because a name on a registry doesn't tell you the size or capacity or reaching of coordination. So a singular registry is an appropriate one-size-fits-all. Why? We're asking you to be registered in one place. We're saying instead of you going and filling out a bank mandate and going by a Ministry X or Ministry Y to be registered, let's have one registry. It is an obligation, yes. There are certain consequences, yes. When you get to fill out the paperwork, if you're not deemed, meaning you're not an existing non-profit organization, company, you fill out the paperwork and you yourself tell the registrar who your controller is. Because to be registered, you have to go forward and say, my controller is Faris Al-Rawi. So this isn't other than by way of self-declaration. You say where your registered office is. You say what your purposes are. You ensure all of these things happen, Mr. Vice President. But let's go further. In this law, in this bill as we propose, we say specifically that there's a registration process. The registrar considers certain documents. We harmonize the registrar's ability to consider documents for registration in accordance with the Companies Act. There's an ability to refuse an initial registration for certain things which I'll come to shortly. And you will see in this bill that we propose that there is a re-registration every 3 years. Why do we say that? The data at the company's registry tells us we have 105,000 registered entities at the company's registry. And a whole 25% of that is in arrears. They have not brought their registration up to date. And why do I say that? Because there is a penalty under the Companies Act, Section 516A, which says if you have not filed your documentation, you're going to pay $300 per month per document. And I'll give you an example. Someone from the public approached me, said, listen, I have not filed my company's documents for 14 years, and I'm still on the register. I said, okay, no problems, approach the registry and let them tell you what you need to do. The person came back in a panicked cold sweat. You know why? The bill for registration was presented. You know how much the bill for not filing 3 documents for 14 years was? $242,800. That's what the law provides for 14 years of not filing your documents. Now, it's a fact that we have given an amnesty in respect of filing of documents, which is going to be aggressively put out beginning May 1st and ending August 31st. But the reality is people will be better off by renewing their registration so they don't get beyond 3 years. Why do you renew a driver's license, a gun license, a bar license, a license to sell food on a periodical basis? Why? Is there not a merit in making sure that your documentation is up to date, etc.? So we propose in this legislation that there is a continuing registration requirement. Yes.
I want to ask, Mr. Vice President, why 3 years? Is there specific reasons why you use 3 years, or that was just an example? Yeah.
We went with 3 years because it's the best in practice formula. And let me get to that. We looked at laws from multiple jurisdictions. We looked at the FATF obligations. We looked at recommendation 8. We looked at the risk assessment under recommendation 1. We looked at immediate outcome number 10. Immediate outcome number 10 deals with terrorist financing and money laundering, and you have to treat with that. Recommendation 8 treats with the regulation on a proportional basis for the nonprofit sector. But what I can tell you is that we certainly have to treat with transparency of ownership, and the recommendation coming from the jurisdictions that we looked at, in particular United Kingdom, Canada, Bermuda, British Virgin Islands, Cayman Islands, Jamaica, Montserrat, Anguilla, Turks and Caicos Islands, being largely guided by the Cayman Islands and the laws coming out of the British Virgin Islands, we felt that the 3-year standard adopted was a useful one. It also helps you to have a regularity of purpose. So, Mr. Vice President, we say that that one size of registration helps us. I'm noticing that time can run very quickly, but I'm trying to make sure that I explain this in as simple terms possible, because I recognize some champions of nonprofit organizations sitting in the public gallery today who I'm sure have some concerns. I thank them for their continued support, be it on sex offenders registry, on child marriage, on a number of issues where we have not agreed on some issues, but very much agreed on others. On the child marriage issue, for instance, our battle was we are not a theocracy, we are a democracy. And therefore, we took a particular position as a government in taking 18 stone coal as an age. So there are times when we will listen and we will act. Government acted in that instance because we found it abhorrent for a 12-year-old girl to marry a 55-year-old man, as the records demonstrated. So, Mr. Vice President, let's get down to the regulator, clause 4. Why the FIU? The FIU has regulating functions, in particular at section 18 of the Financial Intelligence Unit Act. The FIU is the regulator with responsibility to listed businesses, attorneys at law, pawnbrokers, real estate agents, etc., designated non-financial businesses, i.e., nothing that central bank manages, nothing that the SEC manages under the Financial Institutions Act, under the Insurance Act, under the securities legislation. Let central bank handle that. The FIU, under its powers and functions, Section 9 of the FIU legislation, Section 18 of the FIU legislation, allows the FIU to put out directives, to do public education, to do sensitization, to have the ability to come and check upon you, much like the Contractor General in Jamaica does, on a sample audit basis. Yes, please.
AG, thank you very, very much for giving me. Thank you. AG, I just want to ask one question before. I should have asked it earlier, but I think it's an appropriate time to ask it now, as you're on the point about the FIU and the regulator. Do you envisage, and I'm asking this question frontally, do you envisage that this legislation will cover political parties?
Definitely not. Political parties don't fit within that, and I can tell you, In a couple of weeks' time, we intend to lay campaign finance reform, where we will cause the mandatory registration of all political parties. That is the natural cohort to public procurement legislation, and it's been absent from our mandate. So we don't envisage political parties being caught here, because political parties don't act in the trustee-beneficiary type relationship of the definition of non-profit organizations. Thank you, Senator Ramlin, a very sensible question, as always. So we've gone into the regulator. Why have we not gone with a charitable type regulator as the larger community has asked for? Quite simply, it would require the government to come up with a range of powers and remedies and the replication of a new entity with coercive powers of the type that would require reinvention of the wheel. Because the FATF obligation is terrorist financing and money laundering, it was appropriate to use an entity which already has that capacity to supervise that aspect of the equation. If we go next to the provisions of Clause 5, the application for registration is set out. We state what the form shall include. Very importantly, in Clause 5, we say what you must provide. It includes the filing of an anti-money laundering, terrorist financing, proliferation financing questionnaire. It includes providing your controller, who that person is, your place, photographs, etc. We take that information, we give it to the Registrar General. Part of it is entirely private and not disclosable. The personal information aspects, the photographs, etc., those are part of the private registry for law enforcement and FIU purposes. The public registry goes no further than what exists for non-profit companies under Part 5 of the Companies Act as exists right now. Of course, we have to have the approval of names, etc., in the usual circumstance. You can't breach trademarks, names that will cause confusion in the public domain. That's tried and tested in our country, where the Registrar General has the ability to say no to that. We provided an appellate function if you disagree, that you can actually have relief on that. Clause 6, the power to grant or renew registration. Here's where we put the RG with the standard power as exists under the Companies Act, with the power to approve registration or not. Importantly, in Clause 13, where we provide the appellate route, we say an applicant has the ability to apply to a judge of the High Court if your name is refused, you are cancelled, your registration is refused. Why the High Court? Because that's what the Companies Act says right now. It is the due process provision in tried and tested law since the Companies Act has been installed as a feature by way of replacement of the Companies Ordinance, Chapter 31, Number 1, by the Companies Act, Chapter 8101, in the late 1990s, as happened under our laws. We go to that Clause 6, providing the 3-year chain. Again, I've given the rationale for that. It is a refreshing opportunity. It makes sure that people don't end up in the bracket of the $243,000 bounce, or where they're going to be at risk of being struck off because they just can't pay. And that's a sincere reality in this legislation. Clause 7 is where we put the 3-year tie-in to Clause 6. Clause 8 is where we treat a non-profit company registered under the Companies Act is deemed to be registered. So we're transposing all of the non-profit companies onto this register. What time do I end precisely, Mr. Vice President?
45.
Thank you, sir. Clause 9 is the establishment of the Register of Non-Profit Organizations. Clause 9.2 treats with that which is public. We then go on to say what is not public, particularly, and we make sure in subclause 5 that the RG shall not disclose information given under 5.4. That's the sensitive information. Clause 10 treats with the Registrar General having the ability to cancel registration. And we do that basically where the non-profit organization failed to keep proper financial accounts, failed to submit audited accounts if you are over $10 million in gross income per year. That's in subclause E. But when we get to B, C, D, E, etc. through to G, we're providing for where you have a conviction under the Anti-Terrorism Act. You become a listed entity under Section 22B. You've breached the Proceeds of Crime Act. You have been deemed by the regulator to be a risk to terrorist financing or money laundering. But then we make sure to put in the due process provisions in subclause 2 to make sure that notice is given, you have the opportunity to object. After your objections are heard, you get written reasons as to why this has happened. You can then provide for further objections. And of course, in clause 13, we say, if at the end of the day, it doesn't work out in your favor and the Registrar General has acted in this fashion, go to the court. Exactly as you do under the Companies Act right now for a regular company. Clause 11 treats with the updating of the register. It provides for the mandatory reporting requirements to the regulator, etc., the gazetting, standard with the provisions of the Companies Act. Clause 12 provides for the ability for a recommendation for cancellation by the regulator. So that regulator, after investigating under powers under the FIU, and I want to let you know, Trinidad and Tobago has a very interesting FIU law. Unlike other countries, our regulator does not have the power to enter premises unless a court grants that power. Entities supervised by the FIU can say, no, you cannot come into my premises. It can only be done by consent. The international world has told us you have to amend that law. I have flatly told them in my particular turn at the wheel right now, that's not happening. In our country, we will mandate that the court gives you permission to enter where there's a lack of consent, because that is the way protection is offered. When we look to the powers of the regulator,
I recognize you just have 10 more minutes, but a very important question for me. Is this legislation coming under the shadow of the FATF obligations? If so, is there wiggle room for substantive changes or cosmetic changes to this legislation? And what happens if this legislation does not pass?
Nail on the head. So let me stick a pin. In January 2015, under a predecessor Attorney General, Trinidad and Tobago was committed to the FATF formula. We were told that we had to be assessed. We failed the assessment. We are 0 out of 100 in compliance with this law. I've been warning the Senate for months now, since prior to Christmas, that we have a face-to-face meeting with the assessors beginning on the 22nd of April this month. In fact, in my meeting with representatives from the non-profit sector, I indicated the government's intention in attempting to pass this law, having done the consultation that we have done, is to attempt to pass the law. But I give the undertaking that the government will not be proclaiming this law, because what we do usually after we have passed law is we then go into a cycle of further consultation to make sure the law as passed is good to be implemented. I'll give you an example. We passed the abolition of preliminary inquiries very recently in this House. In going out to ask if we were ready to be proclaimed, I got further commentary coming back, and I've laid a new bill in the House of Representatives, because the way in which you operate law requires consultation. And I'm very pleased to indicate that some of the advocates that I met with are intended to be at the Office of the Attorney General at 10 o'clock tomorrow morning to commence the build-out of the NGO reach sector so that we can pulse this legislation into the sector, get the feedback, see what tweaks are required, and then come back to Parliament if necessary. What happens if we don't pass this law? Blacklisting, full stop, shut down your financial sector. It's as simple as that. I've said this since October last year, and this is certainly to the senators of no surprise to anyone here. 5 minutes to go through several clauses. Mr. Vice President, the appellate function is at clause 13. Clause 14 is where we say, keep your records. Make sure your financial data is there. Because you know what? You're a trustee. You're handling other people's money. You must have an obligation to be disciplined. Clause 15 is where we put a threshold. And here is the point that one size is not for all. We say people are required to have audited financial statements only if they are dealing with money over $10 million a year. And we think it entirely appropriate that if you're handling that amount of gross annual income, that you ought to be subjected to the obligation to have audited financial statements. It fits in with the public procurement law in any event, which we have all celebrated as good law. Clause 16 treats with the notification. Clause 17 we intend to amend. Clause 17 goes too far. Clause 17 says, 5 minutes, thank you, sir. Clause 17 says a controller who fails to notify the Registrar General in accordance with 16 commits an offense, liable on summary conviction to fine of $50,000. That was lifted from Section 512 and 513 of the Companies Act, which was the general provisions. We are intending to remove that clause and to replace it with the penalty of $300 per month, etc., in keeping with what exists in the Companies Act in Section 516 capital A. In other words, then, you should have an administrative fine, not a criminal liability. However, we do say that you ought to have a liability if you have false records, if you have not done your audits, etc. And we keep that within the exact parameters of what company directors and officers are subjected to under the Companies Act. This law, I want to say, is built upon the back of an interesting expression of an offense. The interesting expression of the offense is appearing to not have a mental intention. The entire Companies Act is built like that. If you don't do something, if you file a false document, you're going to be guilty of an offense. I'd like to tell you, the system at the Companies Registry requires that when you file a document, there is a proof and reading, etc., and then the Companies Registry sends out a query, and you have the opportunity on query to fix your documentation. And the law coming out in particular from the Mauritius jurisdiction at the Privy Council most recently in February 2019 says you have to have a mental intention to have done so recklessly or knowingly. I intend, because I couldn't do it here, we intend to do an amendment to the Companies Act and this Act to do two things: to provide for the mental aspect of intention, to introduce administrative provisions for those things, and very importantly, to adjust the fines. There are three things actually, because the fines are extremely low when we look at what the fines and penalties are. Some of them we think should not apply, hence the move to administrative treatment, meaning fines, and some of them we think need to be harmonized for the more serious types of offenses. So what we have done to pass muster is to harmonize this law with the existing Companies Act, and therefore we had to be in pari materia. We could not come up with a different formula because we would impliedly repeal the provisions in the Companies Act, and that's just a fact of law, that subsequent law amends prior law in certain circumstances, and we would create confusion. Very importantly, in subsections 21 and 22, 21 deals with the ability of the entity to decide it's going to voluntarily end when we look to the voluntary ending. And what we say in recognizing this particular formula, either on cancellation or on ending, because you are acting as a trustee and because that property is really not yours, it is not for the benefit of the members, we say let the provisions of the Companies Act prevail, which is Section 316, and the formula under the Corporation Taxes Act, if you have charitable purpose, is also managed, where we say that you are to have your property distributed. If you're doing it voluntarily by way of surrender, you will choose the entity that you want, and if it is by way of cancellation, the president does that because you are managing other people's property, not your own. And that is built into our law for many years. In the offenses, we have provided for non-solicitation from the public. Again, if you are a non-profit organization, not the cake sale person, not the charity person, none of them fall within that definition, Mr. Vice President. And very importantly, in fixing the liability of the controller in Clause 24 and in disqualifying under Clause 20, we have simply harmonized this with the Companies Act. We do miscellaneous provisions for the regulator to make regulations for the FIU, being the Minister of Finance, because that's the person who does it. the Attorney General or Minister of Legal Affairs does for the Registrar General, and we allow for rules and subsidiary legislation to come into the mix. Mr. Vice President, I look forward to the contributions of honourable members. 45 minutes does not give one the proper opportunity to give the full parameter approach, but I want to say this is proportionate law from our point of view. The government does not intend to operationalize this law because we have grandfathering provisions, etc., until we have completed a very robust round of further consultations to see what is required and what comes back from the stakeholder sector. I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Provide for the Registration of Non-Profit Organizations, the Establishment and Maintenance of a Register of Non-Profit Organizations, the Obligations of Non-Profit Organizations, and for related matters be now read a second time. Senator Mark.
Thank you. Thank you very much, Mr. Vice President. Mr. Vice President, I rise to make my contribution on behalf of the alternative government on a bill to provide, or an act rather, to provide for the registration of non-profit organizations, the establishment and maintenance of a register of non-profit organizations, and the obligations of non-profit organizations and other matters related thereof, or thereto. First of all, Mr. Vice President, I want to say from the outset, unlike the Attorney General, we on this side view the legislation as disproportionate, draconian, punitive, and in many respects unconstitutional. Mr. Vice President, I will deal with these matters as I proceed to expose the invasion of private property rights and an assault on our Constitution by measures contained in this legislation. But before doing so, may I take the opportunity to let you know that in the United States, there was a revolution because of the British imperialists seeking to impose taxes on the population of the United States. And you know why, Mr. Vice President? Taxation without representation led to a revolution in the United States. Kicked out the British, and they are now an independent state celebrating over 250 years or above. Mr. Vice President, I want to tell this government, on our side, this legislation cannot be fixed. It is not possible to fix it, so the government will have to withdraw it. And Mr. Vice President, we are not going to be bullied by any international organization, and we are not going to be forced under duress and by fear and by deadlines to sell out and to subvert and to compromise the rights, freedoms of our citizens in this republic. We are not under any obligation to do so. Mr. Vice President, we are told by the Honorable Attorney General, 2.5 years, 2.5 years, discussions have been taken on this NPO, and I'll use that for short, for the not-for-profit organizations. And Mr. Vice President, hundreds of organizations, we are told, were consulted. But we are also being told that hundreds of organizations were not consulted. So who are we to believe? So we are hearing that the AG, the Attorney General that is, consulted with the Law Association, and they have a correspondence that they have circulated. They have also consulted with a number of other organizations. Not many, quite read the AG's contribution, both at the beginning and the end in the other place. So I know the organizations that the Honorable Attorney General referred to. But for us in the United National Congress, as the alternative government, we are saying, Mr. Vice President, that we are demanding consultation with the groups, the 100 groups that have not been consulted by the government of this republic. And we say no legislation without consultation. That is what we are saying. There must be no legislation on the NPO without consultation with the groups in question that I would want to refer to as I proceed, Mr. Vice President. So we, Mr. Vice President, looked at an agenda. It looked like this was just paperwork to mamagai and to fool the population and us. But I looked at a legislative agenda, which I received in 2016. And I looked through this legislation. And Mr. Vice President, this goes until 2020. Nowhere in the legislation is there provision for a non-profit organizations bill. So if for 2.5 years the Honorable Attorney General and the government was in consultation, Mr. Vice President, how come this was not on the legislative agenda of the Attorney General and the government? It is not here. I have the agenda. So, Mr. Vice President, this is not good enough. The AG and the government has a practice and a habit of coming last minute with legislation to this parliament and say, Fatif, say, if we don't do this by so-and-so date, blacklisted, blacklisted. That is what they do all the time. They do not give the parliament, Mr. Vice President, adequate time. They do not even consult with people on critical matters. But you come here, we in the United National Congress, who will form the next government, is not and will never be rubber stamp for any government. I want to tell the government that. We will not rubber stamp legislation. We will not do that. Mr. Vice President, when we look at this bill carefully, we see this bill represents an open assault on private property rights by this government as it seeks to bring legislation without any consultation with the various stakeholders. And Mr. Vice President, I don't know if you're aware, but there are many stakeholder organizations that have circulated correspondence to the Attorney General. And the Attorney General has literally, as far as I'm concerned, I read his statement when a letter was sent by some 80-something organizations, and he received it in another place, and he said, I don't want to have anything to do with that. Don't give me no letter like that. It is there in the Hansard. Mr. Vice President, you have organizations like the Board of Social Responsibility of the Anglican Church calling for more time, the Caribbean Center for Human Rights, the Emancipation Support Committee, the Coalition Against Domestic Violence, Family Planning Association, Families in Action, the Islamic Ladies Social and Cultural Association. You have the National Muslim Women's Organization, the network of NGOs of TNT for the advancement of women, Papa Boa, you know about Papa Boa? Conservation, they're asking for time. Pentecostal assemblies of the West Indies asking for time. The Sawa Muslim ladies' organization, Woman TRA, Women's Working for Social Progress, Women's Caucus of TNT. Mr. Vice President, 83 organizations calling on the Attorney General and the government to please meet with us so we can flesh out this legislation, so we can have good law at the end of the day. The Attorney General and the government has said, no, we are not meeting with you, we are not discussing with you, and we are not changing anything. That is what the government has said. And the government comes here today and say what? They have a deadline, and they must pass it, and they are taking no amendments, except what the Attorney General brings. Well, he could go ahead and pass it. He has the majority. It is inbuilt. But we know that this law is going to be taken to the courts of Trinidad and Tobago and will be struck down as unconstitutional. So let them go ahead and pass it. They have the inbuilt majority, Mr. Vice President. Mr. Vice President, it appears that the government has found a tool to clamp down on dissent and critics of the PNM. And this is one of the tools that they are using, Mr. Vice President. My colleague, Senator Ramdeen, asked earlier if this is legislation designed to attack political parties or to regulate political parties. We are told no. We want to ask them if it's also designed to deal with trade unions. I guess they would say no as well, Mr. Vice President. But the legislation is so broad, Mr. Vice President, and so wide and so far in terms of its reach that it can take anybody in that particular area that I've mentioned, Mr. Vice President. This is what is called, Mr. Vice President, under the founding father of that party that is now rolling in his watery grave, Dr. Eric Williams. He described this sector as the third sector, the people sector, cooperative, you understand, NGOs, you understand? That is what, this sector plays a very critical role in the economic, social, and cultural development of our nation. This organization, this NGO, this not-for-profit organization, Mr. Vice President, plays a very important role. And you cannot take it for granted, Mr. Vice President. And Mr. Vice President, we would like to know whether what we are witnessing by these pieces of legislation is not an attempt. Is this what we are witnessing? State capture by powerful interest groups? And they are using these kinds of methods in order to destroy 1,000 times these organizations that have been established over the decades in this country. Mr. Vice President, do you know NGOs create social capital in this land? Do you know that they are the architects within the framework of sustainable development in this country? They are architects and genuine builders of social progress. Mr. Vice President, what we are seeing here is not good for our nation. Mr. Vice President, there are several clauses in the bill which seek to interfere with the rights of property, the rights to hold property by the NPOs without due process, which is a violation of our Constitution under sections 4 and 5. If you look, Mr. Vice President, at the submission of the Law Association of Trinidad and Tobago, they call on the government of this country, Mr. Vice President, to, they found the provision so dangerous. It is November the 22nd, they wrote the government, the Attorney General that is, in response to a letter they received along with the bill on the 11th of October. And they said, among other things, that the proposed bill effectively introduces a policing system toward non-profit organizations. They indicated that there are serious implications for civil liberties and constitutional rights in this piece of legislation. This is what the Law Association told the government, and called on them to find the proper balance between state and these organizations, Mr. Vice President. But most importantly, the Law Association called on the government that before laying this bill, that they do a comprehensive risk-based assessment and review of non-profit organizations, both incorporated and incorporated, non-incorporated and incorporated. And they recommended a legal opinion ought to be commissioned on the proposed bill and a detailed analysis of the impact and effect which the proposed changes will have on individuals' constitutional rights to freedom of association and civil liberties. They call on that opinion to be undertaken with the final report being laid before Parliament for consideration. This is what the Law Association called on the government to do before they even table this report, to provide the country with a proper independent opinion to deal with the rights of people. They throw it in the rubbish bin. They say they're not dealing with no law association. They are in power, but they're only in power for a certain time. They will call an election and the people will have their say. It's only, these things are only for a while, Mr. Vice President. Yes, the NGO will speak at that time, Mr. Vice President. Mr. Vice President, as I said earlier, there are several clauses in the bill which are clearly disproportionate. And they give too much power to the Registrar General, to the regulator, which is now the FIU, which we reject completely. We do not believe that the FIU should have any business with NGOs or not-for-profit organizations. But plenty power, Mr. Vice President, and they can exercise these powers in a most arbitrary manner, Mr. Vice President. So we ask the question, Mr. Vice President, where is the balance of interest of the individual against those of the state? We are told by the Honorable Attorney General that there are over 9,000 or so incorporated not-for-profit organizations under the Companies Act or in the Companies Registry. But you know what? The ferocity and the attack that the government is going after these NPOs, I'm not seeing that as it relates to the other companies for profits, where they are talking about forfeiting these companies' assets, non-profit organization assets. The AG wants to go to court under some spurious grounds to say what? We will take your property, and then when we take it, we will give it to who you want. That's a violation of the people's property rights that is protected under Section 4 of the Constitution. Mr. Vice President, what is happening to these profit companies? Those who are making $23 million in 3 years, what about them? What are we doing about them? They're getting away scotch-free. Are we going to forfeit that money? No, but you're going after the small people. Going after the small people. That is what you're doing. The bacon shark people. That's what you're going after. And nobody could believe. Listen, the AG cannot be trusted. The government cannot be believed. Okay? This bill says, Mr. Vice President, if you are involved in any fundraising activities in this country, you have to be registered. And if you are not registered, you can face both jail and fine, Mr. Vice President. Mr. Vice President, so who is the AG fooling? No one. Mr. Vice President, I heard with my own ears where the AG said that they have looked at the Cayman Island legislation as a model. Well, I have the Cayman Island legislation here. I have it here. It is Law 37 of 2017. And the Cayman legislation goes contrary to what the AG has said. I want to tell you, Mr. Vice President, if you go, and I'll pass it on to you, because I'm sure you don't have a copy, but I will pass it on to the Honorable President. Honorable President, if you go under Section 7 of this law, subsection 4, you know what they do in Cayman Island, a civilized society that want to see their NGO sector thrive and grow and flourish and expand? You know what they do under Section 4?
Title of the bill that you're holding.
I'm saying the title is a Non-Profit Organizations Law of 2017, Law 37 of 2017, Supplement number 4, published with Extraordinary Gazette, number 38, dated the 5th of May, 2017, Cayman Island. That's the publication. Mr. Vice President, under 7 subsection 4, they are calling on the NPOs to come and register every 3 years so they can macro your business. They want information, like the property tax. They want information on people. They want to know who financing who helping who. So they want information. Information is knowledge, and knowledge is power. That is what they are after. Hear what a civilized society is doing in the Cayman Island that we are told that we are following, and that is the model that we are pursuing. In subsection 4 of clause of section 7 rather, a certificate of registration issued under 3C shall have effect indefinitely. Can I repeat that? Under the Cayman Island law, under 7.4, a certificate of registration issued by the registrar under subsection 3C shall have effect indefinitely. We are calling on our NGOs to go to the Registrar General's office every 3 years. To do what? But in the Cayman Island, Mr. Vice President, it is indefinitely. And I want to tell the AG something. I look at this law carefully. You know, Mr. Vice President, we are criminalizing honest and decent people who are involved in this exercise called NPOs. I'm not saying that you don't have criminals, Mr. Vice President. Mr. Vice President, you know my position. I have always stated, and I repeat again, those who do the crime must do the time. There must be no compromise on that. But, Mr. Vice President, don't punish the innocent. Mr. Vice President, don't punish the innocent. They are even in conflict with FATF recommendation 8, where they tell them don't do it the way that you are doing it. It's a one-size-fits-all approach that the Attorney General has taken. And even FATF told them don't go that route. Mr. Vice President, may I also invite you to journey with me under Part 6, Section 16. You know what they do under Section 16 of Part 6 of this law of the Cayman Island that we say we have modeled our legislation after, Mr. Vice President? They have introduced administrative fees, administrative penalties. They are not jailing anybody in the Cayman Islands. They are saying that if you break the law or you violate the law, they will fine you a certain amount of money. But there's no jail fine, Mr. Vice President. Mr. Vice President, in this law, if you violate a certain provision of the law, you pay up to 50,000, you go up to 70,000, you end up in jail for 5 years or a maximum of 7 years. Why must we support the criminalization of the NGO community? Why must we go that route? Why is the government talking about the people of this country. Why would you want to go that route, Mr. Vice President? Mr. Vice President, not only that, when we look at the United Kingdom, that we like to borrow legislation from, and we have the evidence bill coming up, we'll talk about that. Mr. Vice President, there's an act called the Charity Act of 2011. I have a Charity Commission report here with me. In England, Mr. Vice President, United Kingdom, they too have NGOs. You know what they have proposed in England, Mr. Vice President? Rather than you have to go to the court, and then you have to find money, and it takes a lot of time, so many cases and backlogging of cases at the court, Mr. Vice President. The time, the expense. You know what they did in England, Mr. Vice President? They established a tribunal where you don't have to go and pay a lawyer, Mr. Vice President. You can go on your own and defend yourself. The government here in Trinidad and Tobago decides or chooses instead to bring in, Mr. Vice President, what? The court. These are things that the government could have discussed with the NPOs and get some ideas, Mr. Vice President. They didn't do that. Mr. Vice President, we are saying that many of the clauses in this legislation are draconian, they are dangerous, they are unlawful, they are disproportionate, they are arbitrary, and ultimately authoritarian and dictatorial. That is what these provisions are that we have looked at. And Mr. Vice President, let me give you some examples. If you look at the definition of controller, Mr. Vice President, they just got the message, understand, the Honorable Attorney General after pressure. He said he's going to amend 17 because they're going to send Wayne Chan out of the window. But they will not amend 17. But Mr. Vice President, here what's going on. The definition of controller is so wide, it captures all the members of the NGO or the NPO, as I said. Mr. Vice President, when you go to clauses 14, I wouldn't want to detain you this time. I don't have much time. You go to clauses 14, 15, 16, 17, 18, and 19 of the bill. You see, for instance, the net that the government has set for the people of this country and a person they call a controller. These clauses, Mr. Vice President, place upon the controller specific obligations and duties. And once those obligations and duties are breached, Mr. Vice President, that controller commits a criminal offense, and that is accompanied by criminal sanctions. How can you treat people who are seeking to develop this society in a decent and honest way, treat them as common criminals, Mr. Vice President? Mr. Vice President, the FATF said, go after those real bandits that are involved in using NGOs as fronts. But to do that, you must do a proper risk-based analysis and assessment. They haven't done that. We haven't seen that. They haven't circulated that. But you know what will happen, Mr. Vice President? Everybody is placed in the net as far as this government is concerned. Government, Mr. Vice President, offenses are created for the controller, and that is in clauses 17, 18 sub 5, 19 sub 3, 23 sub 2, and 24 2. And we are saying to the Honorable Attorney General, review and rework and remove, if necessary, those provisions, because you need to consult with people, Mr. Vice President, and you need, that is the government, they need to go back to the drawing board. Mr. Vice President, I wanted to also let you know that when you go to clause 4 of this bill, you will see who's in charge. You have a regulator. The regulator is the FIU, Mr. Vice President. That is a body that is established under Chapter 1701 of the laws of Trinidad and Tobago. The aims and objects are clearly outlined. They are a regulatory body, but you're giving them the power to also investigate. That is a conflict of interest. They cannot be regulating and they cannot be investigating. You give them either regulation or you give them investigatory powers. You can't give them both. That's a conflict of interest. And it's unlawful, Mr. Vice President. So we are saying, Mr. Vice President, that the FIU must not and should not and cannot be the regulator of the NPOs in our country. We say remove them, start all over again, because of what we see as a conflict of interest between their role as regulator and their function under the law as investigator. Mr. Vice President, Clause 6 deals with the power to grant or renew registration. Mr. Vice President, there are consequences for an NPO if it does not become registered with the Registrar General. They are telling you, Mr. Vice President, if you do not become a registered body under this particular agency called the Registrar General's Office, there is a criminal sanction. And the Registrar General, of course, has 30 days to register your organization. And under 6 sub 2D, Mr. Vice President, which is linked to 20B, we are seeing, Mr. Vice President, a situation where we cannot, in all conscience, support. Suppose the Registrar General, Mr. Vice President, under these provisions that I've mentioned, refuse to register your or my organization on the grounds outlined in Section 6, subsection 2. And this is linked to the controller in Clause 20, which would disqualify the controller if he's found guilty of a criminal offense, which carry a term of imprisonment of 3 years or more, Mr. Vice President. How can that be fair? How can that be fair, Mr. Vice President? If that is so, then vision on mission gone through. No vision. They have no vision again, given what the government is proposing. And you know what we are told, Mr. Vice President, from the AG's submission? They had excellent consultation with the vision on mission. And they praised Wayne Chance for the work that he has been doing. But poor Wayne know there's a trap they set in for him. And they have a provision to kick him out as the person in charge of. So, Mr. Vice President, that is what is here. So we want to ask the government, how can you be talking about vision on mission and you have a provision here that says if you commit you breach the law and you have a criminal offense and you have a sanction 3 years and above, you cannot hold office as controller. What will happen to persons who are in that situation and they hold office? That is what we must ask the government. Mr. Vice President, Clause 10(1)(c) says cancellation of registration. The Registrar General in this clause can cancel for various reasons, Mr. Vice President. Mr. Vice President, if we go to 10(1)(c) of the legislation, you will see the power of the Registrar General. The Registrar General may cancel your certificate, Mr. Vice President, if it is proven in court that the non-profit organization committed a criminal offense, which carries a penalty of a term of imprisonment of 3 years or more. That is what they are saying here. So the Registrar General has a certain kind of power. I want to tell you, Mr. Vice President, what the government is doing here is putting a certain amount of power into the hands of bureaucrats, Mr. Vice President, to cancel the certificates of NPOs. And there is no real criteria being established in order for them to do so. And they are telling you, Mr. Vice President, when you cancel, when your certificate is canceled, go in your pocket, NPO, find money, and go to the Court of Appeal, Mr. Vice President. Go before a judge. Mr. Vice President, I told you earlier, this is expensive. This is costly and this is time consuming. You cannot ask an NPO to go before a high court judge because you cancel his or her organization certificate and they must find their own income to do so. That is why I told you earlier, Mr. Vice President, in the United Kingdom, what they attempted to do there is to establish a tribunal that you can go to that would not require you to spend any money. If a government really cares about the people, that is what a government would do. The government wouldn't just tell people, go to the court. There's a tribunal. Go to the tribunal. You don't need a lawyer. You can defend yourself. That is what a government that genuinely cares about people would do, Mr. Vice President. Mr. Vice President, clauses 18 and 21 deal with property forfeiture. This is the classic. This is the classical part. Where the Attorney General imagine you have a property, Mr. Vice President, as an NPO, Mr. Vice President. You surrender your property. Okay, so you're moving on. You're moving on. They are saying under this law, you must tell the official receiver, right? Okay, you're going to give up. We are going to tell you how to distribute your property, who to give your property to. How can the AG tell me I have property, I'm a member of an NPO, I am giving up. If my members decide to give X the property, that is our members' business. Yeah. How does the AG and the official receiver get involved in this? And they are going to have that power to tell us who to give our property to. That is unconstitutional. It is unlawful, and we do not support it. It is an infringement of one's property rights, Mr. Vice President. The government cannot mandate anyone in a manner as I have described. Mr. Vice President, this is a very, very serious matter. When we look at clause 22.1, Mr. Vice President, we say we cannot support it because it is unconstitutional. Mr. Vice President, if you have an NPO and that NPO is found guilty under the Proceeds of Crime Act or the Anti-Terrorism Act, the property of that NPO, they say in the legislation, shall be forfeited. Not may, no, Mr. Vice President, shall. So you know what the government has done in this clause? They have taken away the power of the court and the judge in his or her discretion as to how to deal with this property. Mr. Vice President, this is a violation of the Constitution. It's a violation of the separation of powers, and it takes away the discretionary powers of a judge in the courts of Trinidad and Tobago. We cannot, we must not support such a provision. So, Mr. Vice President, I know time is rushing on and passing at the same time. We believe that the government in this legislation is attempting to kidnap, hijack, and control the not-for-profit organizations. And they are doing it, Mr. Vice President, by using FATF as a cover to achieve their objectives. How many minutes do I have again, sir?
12:25, you finish.
12:25. I have 2 more minutes. They are using FATF as a cover to commit this heinous crime. Not they, but what they are doing with these provisions will result in the commission of a heinous crime against the ordinary people. This is wrong, Mr. Vice President. We are saying to the government, this is dangerous legislation. This is draconian legislation. We do not support the Attorney General having any role in going to court to forfeit anybody's property. That is a breach and violation and abridgment of our constitutional rights under Section 4 and 5. And we do not support it whatsoever. So, Mr. Vice President, we have made our position very clear. Don't look out for any support from this opposition to this abomination that is called the Non-Profit Organization Bill. We will not support it. We ask the government to withdraw it, go and consult with the NGOs, the NPOs, Mr. Vice President, meet with them, discuss with them, hear their views, and let the people decide. If you don't do that, you will meet us in the courthouse, right up to the Privy Council. And FATF will then deal with you, not us, because we'll be in power by then. I thank you very much, Mr. Vice President.
Senator Teemal.
Thank you, Mr. Vice President, for the opportunity to contribute to this debate on the Nonprofit Organization Bill 2019. Mr. Vice President, the understanding is that the genesis of this piece of legislation is based on Recommendation 8 of the FATF International Standards on combating money laundering and financing of terrorism and proliferation concerns concerning nonprofit organizations. And it requires countries to review the adequacy of the laws and regulations that relate to entities that can be abused for the financing of terrorism and money laundering. Mr. President, the contribution of NPOs, and I'll continue the abbreviation that was introduced by Senator Mark for nonprofit organizations, the national good is undeniable. We have NPOs as nonprofit companies registered under the Companies Act, as CBOs, community-based organizations, FBOs, faith-based organizations, NGOs, non-governmental organizations, who are actively and historically engaged in the development of this nation in the fields of community development, health and well-being, poverty alleviation, gender equality, education, services to the differently abled, in many cases where no other services are available, penal reform, social justice, culture, sports, environment, animal protection, welfare, and care, just to capture some of the broad spectrum that NPOs are engaged in. And Mr. Vice President, may I state that the spirit that drives the work of NPOs is based on the noblest of human aspirations of concern for your fellow man, and in a true spirit of philanthropy, and for most NPOs, spirit of volunteerism, in which one gives of oneself, one talents, one time, one resources, all for the benefit of your fellow man and for the good of the nation. So any legislation, and this is the first time legislation for nonprofit organizations, any legislation really, irrespective of constraints, whether time or international, the possibility of preventing international sanctions, must be done in the framework of creation of an enabling environment for NPOs to flourish. For when NPOs flourish, the nation flourishes. Mr. Vice President, with regards to clause 13, on page 13 of the proposed bill, I think Senator Mark did mention some aspects of this. And I would just like to add to it in that I think our Honorable Attorney General was at pains to explain and to also indicate that this piece of legislation does not it's not a one-for-all fit. But if we look at clause 13 here, in which, in terms of appeals, NGOs and NPOs have to go to the Court of Appeal, or the High Court, to a judge of the High Court. Mr. Vice President, the reality is the bulk, the majority of our NPOs are small to medium-sized based organizations in which the controller, as is the definition used in this piece of legislation here, is really a volunteer, maybe a professional, the parents of a child afflicted by disease who have taken up a cause so that help could be given to others who are in the same situation because the state is not actively involved, an activist working for a cause. And for such entities, for such small to medium-sized entities, to really have the resources at hand, the money at hand, to go to a judge of the High Court, it really denies a lot of the NPOs the opportunity to seek justice. Scale must be a factor. I think when we are setting up legislation for NPOs, we are talking about organizations doing very noble work, but on a small scale, just ranging from incomes of probably a couple of $1,000s to tens of millions of dollars. Such is the range. And to have this common legislation in which all is treated as one, Mr. Vice President, the contribution of NPOs to this nation is going to be, I submit, it is going to seriously affect the effectiveness of a lot of the small to medium-sized NPOs that are there. Now, the AG did mention, I think the overall figure, when it's added up, it's about $500 million, $500 million that is given to this, the NPO sector, which is a huge sum of money. But I think we have to bear in mind, we have to take into consideration the value that is added to that $500 million by our NPOs. And that value added is not just 12.5%, but that value added is more than double, triple, or quadruple when you think about the volunteerism that constitutes the NPOs. Free of charge, and the reach of the NPOs into communities and into families that organizationally the government is not able to. So it is a very symbiotic relationship that government and NPOs need to really strengthen and develop. Mr. Vice President, I go to clauses 17, 18.5, and 19.3 of the bill before us, where the controller of the NPO is subjected, will be subjected to such very extraordinarily high fines and prison sentences based on summary conviction. The Summary Offences Act, Chapter 1102. I think the highest fine that is there is probably $10,000, or probably thereabouts. And prison terms are probably 3 months or so. And here we are talking about summary convictions, and we are entering the region of $100,000, $50,000 to $100,000, and up to 7 years imprisonment. Mr. Vice President, coming back again, the controller of most of our NPOs, the majority of our NPOs are volunteers. I work with several NPOs, and the time that is put in to manage, to sustain our NPOs, it comes from cadre of volunteers who give of themselves. And imagine the controller, who may be the president of an organization, as most of the times, because you know it's really a sacrifice, being subjected to criminal charges for administrative offenses. Because in 17, 18, and 19, 18.3 and 19.3, we are not talking about the offenses that are placed in Part 3 of this bill, in which the controller deliberately, consciously falsifies information, as laid out in Section 4. I'm not referring to that. I'm referring to 17, 18, 5, and 19.3, where the controller, through no fault of his own or her own, and probably the small group, the executive of the NPOs, fails to do certain things from an administrative point of view. And we are imposing criminal penalties on such a person. These are administrative offenses, Mr. Vice President, and I submit that the penalties should be in accordance with those for administrative offenses. In fact, the company's ordinance are far more lenient. It is far more lenient and generous to profit companies than it is to the controller of our NPOs. Mr. Vice President, you know what I see happening with this piece of legislation is that it is going to be a deterrent. Yes. Yeah. For volunteers. There's going to be a deterrent for those who engage in philanthropy. And as I said, the contribution of NPOs to our social and national good is immeasurable. In fact, without the contributions of NPOs, our social sector is going to collapse. Mr. Vice President, Senator Mark mentioned about Clause 20, and I need to, at the risk of repetition, in a slightly different way, just add. In that Clause 20 really negates the opportunity for a person who has gone through a process of rehabilitation to serve his country through engagement in nonprofit organizations. And you know, a rehabilitated person, having gone through the actual experience of committing probably a crime or being engaged or profiting from the proceeds of a crime, a person who has the strength to go through a process of rehabilitation is so suited to undertake volunteer work to ensure that other citizens don't tread the path that they have trodden. and to deny such persons the opportunity to serve. Of course, I'm not saying open the door and don't have checks and balances, but there has to be some system in place where such persons who want to serve are allowed and not condemned for the rest of their life for some crime that they would have committed. Mr. Vice President, Clause 22 on forfeiture, I consider to be exceedingly drastic. We are talking about an NPO failing to register or having their registration cancelled. Now, registration could be cancelled under this bill for several reasons, like failure to maintain proper financial records, failure to have your accounts audited, etc., administrative aspects of running an organization. And having your registration cancelled, the next step is forfeiture of property. Such a drastic gap. If an NPO fails in certain regards to fulfill the requirements of registration and fails to fulfill the requirements for continuity, or do engage in some act that calls for cancellation, can that NPO be taken to task, action could be taken against that NPO for violations, for legal violations, rather than just jumping to forfeit the property and dispose of the property? I'm asking for that to be considered. Mr. Vice President, I believe that it's a bit unfortunate, as I said earlier, that the first bit of legislation concerning NPOs does not look, due to the limitations of time that I get, is really not looking at the whole thing holistically because of the importance of NPOs. Mr. Vice President, any nation, any country should be looking at implementing legislation, policies, and measures designed to promote, support, and enhance the capacity of NPOs to perform these functions. It should also be looking at developing the ability of the NPOs to become more effective partners with government, and the private sector, to equip NPOs to ensure that they maintain high standards of practice and good governance. And of course, together with what we are looking at, two important things. One, to really bring that about, to really achieve that, the process of consultation must be there. Because the Act should also be looking at how to create an enabling environment for NPOs to flourish, not just only looking at penalizing, but creating that enabling environment. And, Mr. Vice President, within the Ministry of Social Development and Family Services, there is the non-governmental organizations unit, which was implemented, I think, in the year 2013. And I would like to suggest that this unit be expanded into a full-fledged division within that ministry. A full-fledged division with appropriate director and staff and fully supported, so that a symbiotic relationship between government and NPOs could be fully developed, and that the government can really work together with the NPOs to allow them to achieve high standards of governance, allow them to understand, be educated about registration, because it may look simple, but for a lot of the small to medium-sized NPOs, this whole process of registration, getting accounts audited, all of this thing, is really going to be beyond their means currently. And it means a lot of them having to take measures, drastic measures, to make that jump in order to satisfy this piece of legislation. And finally, Mr. Vice President, and Senator Ramdin did preempt this part of my contribution. I was going to ask about the political parties and whether they, in terms of, would fall under non-profits. The AG did mention that legislation is coming about election campaign, but just as a point of note, in terms of political parties, it's not only just a question of election campaign funding. It's a lot more broader. We are subjecting NPOs to this rather elaborate legislation. And I would just humbly submit that in order to achieve all what we are looking at, that political parties would have to be party group would have to be subjected to the same. Mr. Vice President, I thank you.
Senator Seepersad.
Thank you, Mr. Vice President, for the opportunity to contribute to the debate on the Non-Profit Organizations Bill 2019. As has been said by Senator Mark and Senator Teemal and others, non-profit organizations play a very significant role in our society by delivering services to the public which are not provided by government and other organizations. I do think there is need to have legislation to reform and consolidate the oversight of NPOs to enable volunteerism, philanthropy, and to strengthen NGOs and the government's compliance with the international financial system. However, this legislation, as has been said, is a one-size-fits-all. It is punitive and goes beyond what is really required to prevent terrorist financing and money laundering by a relatively small group of organizations. You need to find a balance in government monitoring of NPOs for the violation of anti-money laundering and counter-terrorism laws with the international obligations under the Financial Action Task Force Recommendation 8. Recommendation 8 and the interpretation note by FATF in its best practice paper on combating the abuse of non-profits includes the following: apply a risk-based, focused, and proportionate approach to the NPO sector and not disrupt legitimate charitable activity. Mr. Vice President, given the scale and diversity of the NPO sector, implementation of this bill will require substantial financial and human resources which NPOs really do not have. Nonprofits are usually resourced by volunteers who give of their time on a part-time basis. The onerous nature of this bill could lead to the closure of many NPOs and stymie the addition of new NPOs. I would like to pose the following questions to the Attorney General. The separation of responsibilities is crucial to sound policy decisions. Therefore, how can the Financial Intelligence Unit be both the regulator and investigator of non-profit organizations?
Good point.
Why are audited accounts only required for NPOs with incomes over 10 million and not all NPOs, since these organizations are in fact acting as trustees for funds under its management? And are there plans to have a robust education campaign to inform and educate NPOs on the requirements and obligations of this legislation? Mr. Vice President, the intent of this bill is the furtherance of international obligations. I understand that. But it appears that due consideration and consultation was not done. It is imperative that a workable model be found so as not to destroy the benevolent intent in Trinidad and Tobago. Who will want to volunteer in what appears to be a hostile and punitive environment? Thank you, Mr. Vice President.
Minister of Labour and Small Enterprise Development.
Thank you very much, Mr. Vice President. Thank you for the opportunity to participate in this debate on the Nonprofit Organization Bill 2019, which is an act to provide for the registration of nonprofit organizations, the establishment and maintenance of a register of nonprofit organizations, the obligations of nonprofit organizations, and for related matters. Mr. Vice President, I sat here and I listened to the contribution of my good friend, Senator Wade Mark. Very melodramatic as usual, attempting to utilize what I call the UNC fear factor, which really crashed in another place yesterday. But Mr. Vice President, I would like to assist in allaying some of the fears that have been expressed by two independent senators so far, Senator Teemal and Senator Seepersad. Senator Teemal holds the view that this piece of legislation would lead to the demise of NPOs, a view that was seconded by the contribution of Senator Seepersad. But I want to agree with him that when NPOs flourish, a nation flourishes. But the senators have looked at what is interpreted as the negative aspect of the bill, and I would contribute in that regard. But I hear what is coming out, that the NPOs, small to medium size, the majority of them would be affected. But I want to remind the honorable senators that this bill focuses on those NGOs whose income is more than 10 million. I want to remind this honorable House of this honorable chamber of the statement made by the Honorable Attorney General when he pointed out that the government's contribution to the NGOs range in the sum of 500 million. And therefore the question is, shouldn't there be a threshold of accountability for the taxpayers' funds? I don't think that is the intention of any of the, and I'm not talking about the UNC in the House, but to the honorable independent senators. I don't think the intention is that the NPOs must not account for the taxpayers' funds. I hear the concerns, but what I was hoping to get a little more from the senators is some suggestions on what can, because the government is open to amendments. What are some of the ways? It is okay to point out what is believed to be the troubling aspect of the bill from your perspective, but I was hoping to get a little bit more from the independent senators, but perhaps their colleagues may provide me as a member of this honorable House with what are some of the suggestions as we go forward. But Mr. Vice President, in my opinion, Mr. Vice President, I want to make my contribution in silence, please.
Members, could you please allow the minister to make a contribution without having the ambient noise or the background noise elevating to a level that she'd have to actually elevate her voice to speak over. Continue, Minister.
Thank you, Mr. Vice President. In my opinion, this proposed legislation before us is simple. It seeks to provide for the supervision and registration and regulation of non-profit organizations and to make the necessary provision in this regard. And Mr. Vice President, one of the purpose of us, we are here to make laws. And in doing so, we would not all be on the same page at the same time, and that is where the discourse comes, where senators in this House would offer alternatives to the government. Criticism is good in itself. It's not healthy if it's not constructive criticism. But, Mr. Vice President, there is no doubt that globally the scourge of money laundering, financing of terrorism, and the weapons trade is a perennial problem, not only in Trinidad and Tobago, but internationally. Trinidad and Tobago, despite its size, remains susceptible to these threats, and it is the duty of this government, and I dare say any government, to ensure the integrity of our financial systems and the well-being of our citizenry. Mr. Vice President, it is important to remind ourselves that Trinidad and Tobago is a member of the Caribbean Financial Action Task Force. This country is a member. And the main objective is to ensure the implementation of and compliance with the Financial Action Task Force, FATF, recommendations. And these recommendations seek to prevent money laundering, financing of terrorism, and the proliferation of the weapons trade. Mr. Vice President, in keeping with our obligations under the FATF, the government of Trinidad and Tobago have thus far passed the following pieces of legislation. 1, the Anti-Terrorism Amendment Act number 13 of 2018. 2, the Miscellaneous Provisions, Proceeds of Crime, Anti-Terrorism, and Financial Intelligence Unit of Trinidad and Tobago, Act number 20 of 2018. And 3, the Miscellaneous Provisions, Mutual Assistance in Criminal Matters, Proceeds of Crime, Financial Intelligence Unit of Trinidad and Tobago, Customs and Exchange Control, Act number 2 of 2018. So then, Mr. Vice President, when this government has been making meaningful strides in reforming and regulating our financial systems, and this bill is but a continuation of that work. And I want to recognize the effort and the hard work of our Attorney General in this regard. This bill, Mr. Vice President, reflects this government's commitment to keeping Trinidad and Tobago in line with requirements of FATF Recommendation 9 and Immediate Outcome 10, which specify addressing non-profit organization. This, at present, Mr. Vice President, there are an estimated over 7,000 nonprofit organizations operating in Trinidad and Tobago. And yes, all of us are aware of the important role that NPOs serve in this democratic society of ours. The primary role and focus of a nonprofit organization is to lobby and to raise issues of public interest and assist the citizenry of Trinidad and Tobago where the resources of the government are unable to do so. Nonprofit organizations play an integral role in our society, especially community development, and they provide support in a variety of sectors, including sport, education, public awareness, and religion. So that, Mr. Vice President, recommendation 8 of the FATF requires countries to review and amend its laws and regulations that relate to nonprofit organizations and to ensure the integrity of its operation. And this is what this bill simply seeks to do.
Honourable members, the time is now 1 o'clock, and I think it's a good time to take the lunch break. As a result, this House will now stand suspended for 1 hour until 2 p.m.